is the access to public records. And this is similar, as I mentioned, in concept to the Open Meetings Act. Once you get the idea down, it's pretty easy. It's the same idea. All meetings are public except for the exceptions where they can be closed. Same thing with records. All records are public except for the exceptions which they're not, which is reflecting the view, which is this is a public good. People should be able to see how their government is working, so they should be able to see the records that their government officials are looking at as well, the documents, which used to be papers, but now, of course, are all sorts of electronic stuff as well. So they have a variety of exceptions to the public documents. And in fact, I think, like I said, I think there's 27 because it goes to AA. So if my math is right with A to Z and AA, there's 27 exceptions. But I'm going to just deal with a couple of the big ones, the things that are not public. And one of the big ones at the beginning is this personal or other personal, individually identifiable records, otherwise deemed confidential by federal or state law or regulation, or the disclosure of which would constitute a clearly unwarranted invasion of personal privacy pursuant to 5 U.S.C. 552 et sec. Right? All simple? I don't need to talk about that at all, right? No. So there's two separate things here. Actually, one is pretty simple. If it's deemed confidential by federal or state law or regulation. And that's pretty simple. And really the big things there are the stuff like healthcare records. Pretty much all healthcare records are confidential, things like that. Your social security number, your credit card numbers, actually credit card numbers are a separate item that are not covered. So that stuff is pretty clear. But then they've added this to the law. It used to be, for many years, that was it. Everything's public except for these exceptions. And the exception was sort of if you had this personally identifiable personal record. But then they added this disclosure of which would constitute a clearly unwarranted invasion of personal privacy pursuant to 5 U.S.C. 552. Well, 5 U.S.C. 552 is that Federal Freedom of Information Act. So they basically kind of tied it to that. And clearly unwarranted invasion of personal privacy. Well, geez, you got 5 things here. You got privacy, personal, invasion. Is it unwarranted? Or is it clearly unwarranted? Maybe it's unwarranted, but not clearly unwarranted. What the heck does that mean? So I'm going to take a little time to talk about what the federal courts, because this is nationwide, over 30-some years, over the entire country, there's a fairly good body of law of what that means. And essentially, it's a balancing test. We're going to balance the private interest against the public interest. And the way we do it is kind of in 4 steps. And the first thing is the information identifiable with a specific individual? If it's not, then there's no protection. If it's to a large group of individuals or an organization or something like that, then it's not a personal thing, so it doesn't apply. You don't have to worry about it having that exception. So it's a public document. Then the next thing you look for, well, is there a privacy interest to be protected? And there's a certain things to look about with the privacy interest. Say, for example, it's something that's already in the public domain. It may be one of those confidential things, it might be health records, but if it's already been published in the newspaper, or if it's already been spread all across Facebook, then it's in the public domain, there's not a privacy interest. If someone is dead, there's not a privacy interest that applies. So if you're looking for records about a deceased government employee and whatnot, their privacy interest goes away when they're dead. I will tell you that privileged communications between lawyers and clients, at least in Massachusetts, do not go away when the client dies. And if you want to see where that comes from, or where it goes to at the end, you can go to the successor law firm that defended Lizzie Borden.
And they have records that they have not and will not make public because they say they're still protected by attorney-client privilege. But as far as public records, if you die, then your privacy's not there. And again, organizations, corporations, so forth, they don't have a privacy expectation. So that's easy. So if there's no privacy expectation, then it's public record. So if there is a privacy interest, then we got to look for the next thing and say, well, what's the public interest? And what does public interest, for the purposes of the Freedom of Information Act, is information that sheds light on an agency's performance of its statutory duties. It shows what the government is up to. So that's the public interest. Again, the basic right here. We want to know what our government is up to. Are they doing right by us, or are they trying to get us? Or are certain people trying to manipulate the government to get us? Those are all legitimate questions. No matter what we believe the answer to them may be, they're all legitimate questions, which if the information fits, then that's the public interest. And then finally, the fourth part is balancing that public interest. The right of the public to know about these things and how its government works versus the right of the individual to have privacy. And I can't say that there's any kind of magic bullet involved here, but I would say that when you look at the total scheme of Rhode Island's law, and based on the federal law, and the idea that everything is public except for the exception, if something comes down in the middle between privacy and public, then it should flip over to the public side, because that's what we're trying to do, is make these things public. So that's the big thing on the personal issues. A few other exemptions from public records, which are perhaps useful or good to know about. Again, there's any records which disclose the identity of a contributor of a bona fide and lawful charitable contribution to the public body when they've requested anonymity. This is a little bit broader. The open meetings one is limited just to libraries. This is broader, any charitable contribution, but clearly this is the flip side of protecting the meeting records if you've got an anonymous donor, and then the further records going forward in time are protected as well. Or if we had someone who came forward and wanted to just write us a check to the town of Tiverton, help with our tax issues, but wants to keep it private, then that wouldn't be a public record. Now people may say, wait a minute, we have a right to know who's doing this, but that's an exception. We talked about minutes before. One of the exceptions is any minutes of a public body which are not required to be disclosed pursuant to Chapter 46 of Title 42. Well, that 46 of 42 is the Open Meetings Act. So again, if you've made a motion to seal your minutes, then they're not a public record. Probably the two biggest ones that we have the most conflict over are K and M. K is entitled Preliminary Drafts, Notes, Impressions, Memoranda, Working Papers, and Work Products. Provided, however, any documents submitted at a public meeting of a public body shall be deemed public. So we have two parts here. We first have these preliminary drafts, notes, impressions, memos. And this comes down to the question we had earlier about Steve Berlucci. While Steve's working on that memo to the street committee and researching it and putting it together about what he can find out about certain streets, that is not a public record. It's part of his work product. It's one of these exceptions. The idea is that government employees should have the freedom to be able to do their work. If it's not public anyway, they should have the right to do it without it being forced to become public. Those preliminary drafts, memos, etc., are not going to be public. However, the minute they're submitted, and I'd say submitted needs to be read very broadly, but submitted at a public meeting of a public body, then they're public. So submitted could be the thing we talked about of, certain letters may be submitted by people who come up on different issues. Once they're submitted, those are public records. They should be available, the public should be able to know that they exist which comes to the fact of having either referencing them in the minutes or attaching them to the minutes. And if you're referencing them in the minutes, then they've got to be available so that someone can file a request and within 10 days be able to get a copy of what's there. And even if it's not something that's formally submitted, but if it's part of your packet, if it's something that's relied on and used in the meeting by the members of the public body, it becomes a public document as well. Yes.
Yeah, how about zoning board petition?
Yes.
You take the petition and you go out and you look at the site.
Yep.
You make notes and one thing. Does that become work record? I mean, it's partially gonna base what you're listening or questions you had or one thing or another. And you made all these notes that you.
Okay.
put in the minutes.
Right. Well, what I would say is, it's not a public record until you're at the meeting. And at the meeting, if you're looking down at your notes and you're saying, I noticed this, and I saw this, and I saw that, then I would say it becomes a public record. You should probably hand either the original or a copy of your notes to the clerk of the board so that it can go in the record. That's all you have to do to make it public, that people can see it, that it's something there. But if you're, that's what I'm saying, if you're using it, that to me is something that is submitted at a public meeting. If you're reading down all these notes, or if sometimes if someone, member of a body drafts a draft resolution, they hand write out the resolution or the vote that they want to do, and they read it at the meeting, that is a public record once that's done. Okay? The other thing is exception M, which is correspondence of or to elected officials with or relating to those they represent, and correspondence of or to elected officials in their official capacities. So what this does, it allows people to write to their town council member and say, you dirty skunk, you're doing a terrible job, how can you possibly do it? That's not a public record. Well, you're doing a great job, and I hope you run for re-election, and here's $100 for your campaign contribution for next week's cocktail party that you're having. That's not a public record. Now, the campaign contributions, I'm joking, those have their own separate disclosure and so forth. But the correspondence with the elected officials, those aren't public records. That's, again, it's part of our balancing thing. We're balancing out the people's right to petition their government for redress of grievances, to talk to their representatives. And we're going to talk this in ex parte communication in a few minutes, how it's a little bit different for town council members, the legislative body, than the rest of you. But that's one of the specific exceptions. This doesn't affect a lot of you because we have kind of narrowed down the public records officers here in the town to 3. We have basically 3 public records officers. While the law requires that you set forth who it is who responds to it. And for the police department criminal stuff, it's the police chief. You want arrest records and investigative reports, you go to the police department, and it's the police chief who's responsible for timely responding. If you want stuff with the administrative offices and the boards and commissions, you go to the town administrator. He's the one who's responsible for that. If you want something with the clerk's area, with the town council, vital records, land records, you go to the clerk. And I think we put the treasurer under the clerk just for convenience, since it's a small office there. So if you want treasurer's records, you're going to go to the clerk. And why have we done that? Well, we've done it for a couple of reasons. First of all, because those 3 people have to either attend or watch on TV the hour-long session from the Attorney General every year about the records and certify that they've done it. But also because it's important to respond quickly. And this is where all the rest of you come. Because the law says people don't have to use, I can have an official public information request form. Here's my public records request form. And this is what I'd like you to fill out. But if someone doesn't want to use it, they don't have to. Anything that is identifiable as a public records request is to be treated as a public record request and responded. So this is where every one of you come in. If someone sends you something, and it's probably going to be an email, that looks like a public records request, you need to get it to the particular party, which for most of you is probably going to be the town administrator, since he's the public records officer designated for all the boards and commissions. You need to make sure that he knows about it right away, because you've got time frames. You've got 10 days, you've got 10 business days to respond. And if you need more time, you can get up to 30 days, but even then, and it's not you, it'll be the town administrator, has to send the thing saying why we can't get it in 10 days, it's very voluminous, it's buried in the vault, whatever, but has to explain why it's going to take us up to 30 days instead of 10 days. But those time frames are there, and many of the people who make these requests will not have a lot of patience and will file a complaint with the Attorney General, and after a while the Attorney General loses patience, and there will be fines, and those fines can go against individuals as well as the town. So probably not a lot unless it's an egregious error, but if you don't want to be paying a couple $100s to the Attorney General, then make sure you act quickly. If it looks like, if it quacks like a public records request, and waddles like a public records request, then treat it like the duck and move it on. Or even if it doesn't, if you got any doubts at all, move it on and make sure that it gets some priority. Follow up. If you forward the email to the town administrator, make sure you follow up with, if he doesn't send you a response in a day or so, follow up with a phone call. Did you get it? Or get it. Make sure you get some kind of response on that. That's what your job is. All of you out there. If you get anything that looks like a public records request, get it to the relevant person right away so we can respond properly. And that also includes requests for documents that just don't exist. Because it's part of the law that even if we don't have it, we have to tell them that within 10 days. And we've gotten reprimanded for that. Someone came into the clerk's office and asked for 5 different things. And the person at the counter was very helpful and said, okay, here's 1 and 2, we got that, give you 2 right now. Number 3 doesn't exist. Number 4 and 5 you can find in the treasurer's office. And they went down, they got 4 and 5 in the treasurer's office, but no one responded in writing and said, number 3 is something that we don't have. It's not in our possession, we don't have it. And that's what you have to do to respond. You have to respond in writing if you don't have it. So even if you get a request for something, oh, no, town doesn't keep that kind of thing, that's not a public record. You make sure we get it so that we can tell them that in writing within the time frame, no, that's not a record we keep. So. Further questions on public records? No? Okay. Ethical behavior, the Rhode Island Ethics Commission governs this. As I said, it's in statute. There are also regulations. And the gist of it is that you're not supposed to be doing any of your public action for any kind of private gain. And that private gain can be, actual money to you, it can be money to a family member, it can be money to a business partner, or it can be even private gain of, revenge to your neighbor who you've been feuding with all this time. If there's a quid pro quo involved, those are the sort of things. And it also means the appearance of it. Maybe none of those things apply, but there's an appearance. One of my examples is, you're on the zoning board, and Joe Smith is coming before you. I hope there's no one Joe Smith here. I'm just using generic names. Coming before you. And you and Joe have been buddies since high school. You're not related. But you have been buddies since high school. You hang out together. You go fishing together. You're really just good friends. Your families go out to dinner together. Maybe, whatever. You're good friends. And this is a small town, so people know that too. And now Joe's coming before you for a variance for his house. You don't have a conflict of interest under the Ethics Commission rules, but you sure got the appearance of impropriety. Unless there's no quorum or something, unless you've got a real otherwise problem, you should be recusing on that. Don't let people even be able to say, oh, of course he voted for him because it's his buddy. Or the other way, it's, It's Jane Doe, who you've hated for years. You've had a feud since high school when she stole your boyfriend, and you're on the board, and now she's coming before you. And the whole town knows that you two have it in for each other. Don't sit there and rule on her petition. Recuse yourself. Keep that appearance of propriety. Keep that appearance, not just the reality, that you're going to judge fairly. Now, you probably can judge fairly, but it's still not something that people are going to like when they see it. I used to say the easiest thing, I used to call it the Providence Journal test. I'd say, if you're going to do something, and you're wondering about it, think about how is this going to look on the front page of the Providence Journal when you read it in the next morning. Or if you don't have any scruples yourself, what is it going to be when your mother or your spouse or your children read this on the front page tomorrow morning? Now, with the Providence Journal, I think I need to change that, I think, with the Times. I'm now going to call it the Facebook test, okay? So when you're about to do something, and you're wondering, should I do it? How does this look? Think about that. What would my mother say? What's my daughter going to say when she sees this spread across, and it'll be far wider than the Providence Journal could ever spread it. When this is spread across Facebook and goes viral on Twitter and Tumblr that I did this, how am I going to feel about that? And 95% of the time, just trust your gut on something like that. If you're not going to be comfortable, if you think, I'm not going to be comfortable if that comes out tomorrow like that, then don't do it. Okay? I do want to note specifically that there is an option, if there's a question, you can seek an advisory opinion from the Rhode Island Ethics Commission. Now note, you can call them up and talk to them, and they'll give you some advice, but you can't rely on the advice the staff people give you over the phone. Although if they tell you should recuse, you could go at that point and say, okay, I'm recusing, you're okay once you recuse. But you do have the ability to request a written opinion from them, and the Ethics Commission will consider it at a regular meeting, and if they say that it's okay, that you don't have a conflict, then you're protected. So that is an option. Now, I'm using this term recuse, and it's a technical legal term, although probably most of you have heard it now in this context, but what does it mean? Recuse means if you do have a conflict or this appearance of a conflict, a potential conflict, you stop participating, you don't participate at all in the process. And there's a difference between abstaining and recusing. Abstaining is just saying, I'm not going to vote on this. Abstaining might be, you're at the planning board, the thing's been going on for 4 months, and you only made 2 of the 4 meetings, and you don't feel you've got enough information to vote on it, so you're going to abstain. But you can still be there at the table. You can still be part of the process. When you recuse, you get out of the process completely. The advice that we always give our clients is get up from the table, walk away from the table, ideally leave the room. If you've got a board thing, if you know about it, you're on the zoning board, you know you got to recuse for an item. Have them put that as the last item of the night, so you can go home, and you don't even have to hang around. Or have them put it on the first item, so you can come late. Don't be there. The best thing to do is just be not in the room. If you want to stay in the room, sit in the back. Don't be like the former town council president from the town to our south, who sat in the front row of the council chambers kind of giving hand signals to the council members and resulted in a complaint. Okay? So don't do that. Sit in the back. Just get away. If you can, leave. If it's not freezing cold, if you got to wait around for the next one and it's not freezing cold, wait outside. Or if it's freezing cold, go out, sit in your car, or run the engine a little bit. It's worth paying for the gas to avoid the ethics complaint.
You have to state that, so it's part of your meeting.
Yes. What you have to do is the member who's recusing needs to say that they're recusing themselves. Now, I think it's better that they state right at the time why they're recusing themselves, but that's not technically an absolute requirement, but they do have to put it in writing, because that's the other part of recusing. You have to fill out a form that says that you're recusing yourself and why, what the particular conflict or potential conflict is, And there are 2 copies of that form, and one of them stays with the records of your board, wherever it is. If it's the, the secretary of the board, or if it's the town clerk for the council, or the zoning board secretary, it stays with the board. The other one goes to the Ethics Commission, copy of it. So it's public anyway, so you might as well say it out loud while you're recusing yourself.
I have a question about that.
Yep.
Let's say you accuse yourself, but the petition affects you personally. Like, let's say they build a house next to your own house.
Yes.
You're a member of a board. So you accuse yourself, but you cannot come up as a public citizen.
Well, yes, you can. There is an exception to that. You can speak. You still have your First Amendment rights to come up and say why you're against it. My advice to you is still not to do it because of the appearance. Have your wife, have your spouse, hire a lawyer, have someone else come up and do it rather than you. Just think how it looks. The one minute you're up here deciding on people, judging on things, and the next minute you're out there advocating for a cause. So if at all possible, avoid it. You don't want to be doing that any more than you absolutely have to. Now, I also want to point out, too, there are 2 boxes on the Ethics Commission recusal form. We call it a recusal form, but it's actually a disclosure form, because that's a big part of the Ethics Commission, again, making this stuff public. And that's a whole other thing I'll get to in a minute. But there's a second box that you say, okay, I'm a member of this body, I'm a member of the Tiverton Zoning Board, and a matter involving Joe Smith has come before the board, and I am, whatever the particular reason. And then you can check one, I'm recusing myself, or the second one, I'm not recusing myself, I can hear this fairly because. Example might be, for zoning board, for example, the planning board. If you're living within the notice radius of an application, you're pretty much automatically got a conflict and need to recuse. But what if you're not? What if the notice is 400 feet and you're 600 feet away? Maybe you may say, well, I'm 600 feet away, and I can hear this. It doesn't affect. What they're going to do, they're going to put a deck on their side of the house away from me, and I'm 600 feet away anyway, so it's not going to affect me. So you can do that. You can say, it's 600 feet away, and I have no conflict. It won't have any effect on my property. So you have that ability to do. I don't recommend it if you have the option to recuse and there's still a quorum, your alternates and everything like that, the best thing to do is recuse. If you think enough that you've got to do that, the best thing to do is recuse. But if you have to, at least, again, that provides some protection, because that's what the Ethics Commission is looking for, notice the public. Remember, we want the public to know how the business is conducting. The public needs to know, because unless you tell them, small town or not, how many people are going to know that you live 600 feet away? They're not going to know unless you tell them that you might have some kind of interest. And if you tell them, then they don't think it's not sneaky and underhanded if you've told them publicly. And that's similar to the other big aspect of the Ethics Commission requirements, which are the annual financial disclosure forms. It's not that there are some limits on what you can get as gifts and whatnot, but it's that people know where's your money coming from, where's your income, who are your business partners. That stuff has to be public. So let me also give you a reminder there. You should all get these forms in April, and most of you should be filling it out. There are some requirements. They've eased it up a little bit, but if you've got any questions, give us a call. It's kind of like taxes. Even if you don't get the form and you're required to submit it, it's still a violation of the law not to submit it. Now, they're pretty good. First things they'll do is send you a reminder letter, and you really have to ignore them for a long time before they start fining you. But if you have any doubts or questions, whether it applies to you, get in touch with us. It's a whole complicated list of criteria, and I'm not going to get into the details now, but most of you probably, if you have been doing it, you still should be doing it. Make sure you do it. It's easier now. It's online. If you have no changes from the year before, it's a lot easier than it used to be. You used to have to refill out the whole damn form by hand every year. You don't have to do that anymore. So make sure you do that.
Plus, you don't have to get it notarized
No.
if you do it
So,
online.
yeah, that's right. So,
It comes for email to us?
no, I don't.
No, it doesn't.
I think it's still coming in a hard copy, and then you can go online to do it if you want, or you can return the hard copy. I just want to add something about abstaining again. Just zoning board members cannot abstain, okay? You cannot abstain. There's a case on that. we dealt with recently in another community, or a couple of years ago in another community. A zoning board member cannot abstain. You can recuse, you got a conflict of interest, you're not going to hear it, but because of this requirement that zoning boards absolutely have to have 5 members as a quorum, and those 5 members voting, a zoning board member cannot abstain. You're going to vote one way or the other. If you're there and heard the case, and you're one of the 5, or you're the alternate, and still voting because someone else isn't, you can't abstain, you've got to vote.
I have one more question about that. I think I know the answer because I already stated it to somebody else. But if somebody in town, similar business, applying for something eventually would benefit me if it passes,
Mhm.
I should have accused myself of something.
Yes, yeah. I mean, again, it's how is the appearance it's going to look. And it's kind of a difference too if there's a lot of it versus 1 or 2. If there's only 2 businesses and this is the only other one in town, then not, And maybe, they're in a similar business and they're going to be competition to, maybe you're happy because you think it's good, but the public may not like that. They may think, oh yeah, this is competition, so he's going to not want to vote it. So you want to avoid that appearance.
I'd like to mention one thing on the Ethics Commission. A couple of times that I've asked for an opinion on something, what I actually got back was an administrative opinion. That doesn't mean anything, because the commission hasn't voted on it. But what you get back most likely in time to use it for the meeting that you requested it for, really comes back as an administrative opinion.
Right.
Not really the decision of the commission yet, because they haven't voted on it.
Right, and that's correct. And if so the board's able to move on without it, then it's going to be de facto you're recusing yourself because you're still waiting for their decision. As I said, the administrative decisions are more helpful when they're telling you you should recuse than when you're not. And I'll also tell you too, that the Ethics Commission has said in rulings that you cannot rely on the advice of your town solicitor for this conflict of interest stuff. Case down in Westerly where the town solicitor said, oh yeah, no, that's not a conflict. Go ahead and participate. And so when this guy was brought up on charges, he said, but the solicitor said I could do it. He said, no, you can't rely on the solicitor for that. The only thing you can rely on is a written decision of the Ethics Commission itself. So let's talk about the appearance of impropriety and more about how that goes, and particularly this thing about ex parte communication, because I think that's often the most difficult problem in a small community, is that you run into people all the time, and they want to tell you how you should vote on something, or they just want to tell you how they feel about something that is either before you currently or about to come up, and they want to tell you about it. And frankly, if you're not going to be a hermit, you're going to deal with this. You're going to be at the local businesses. You're going to be out there. Part of the reason you're on a volunteer board to begin with is because you're a member of the community and you care about it. So you're going to be out there at these events. You're going to be at the parade. You're going to be at the concert at Sandy Woods. You're going to be there. You're going to see people, and they're going to want to talk to you about these things. And this is where we get to a little bit of a split between the council members and the rest of you. Because the council members have to listen to people. If they expect to remain council members in the future, they can't just say, shut up and get away from me. They have to listen to these people. Or at least they have to listen to for a longer period of time than you do. For the rest of you, the boards and commission, when someone starts talking to you about something that's before you, you want to shut them off pretty quickly and say, that's before me, I can't talk about it. You need to come to the meeting. That's what you need to say. You need to say, you need to come to the meeting and speak. That's your first response. It's next Tuesday. It's next Thursday in the senior center. You need to come to the meeting and tell everybody that. I can't really talk to you about it. And then, of course, things, I can't do that. I'm too busy. I got the kids that meeting. I got bingo then. I can't make that meeting. Let me tell you now. So you got to go to the second fallback, which says, well, we'll put it in writing. Send a letter. Send a letter, and again, here's where it comes into the clerk. If it's town council, send it to Nancy Mello. Send a letter to go to the records. Send it to Jody if it's a zoning board. Send it, just address the zoning board and clerk. Send it to the administrative officer of the planning board. Put put your comments in writing, it'll get into the record. Oh, I don't have time to write, I don't want to do that. Well, send an email to that person. Again, not to me, don't send me an email. I can't really be talking about it, but send it to the clerk, it'll get in the record that way. That's what you have to do. And the town council members kind of have to do the same thing, but you have to probably listen and nod appropriately for about 5 minutes before you can get to that point of saying, I appreciate your feelings, why don't you come to the meeting, or why don't you put it in writing? But that's what you have to do, because you want to refrain from it. Now, let's take the further thing. You told them to send the letter to the clerk, they send it to you. The old days, they stick it in your mailbox, or they send you an email. Suddenly you've got an email from someone telling you about how they think about this petition that's coming up next week. What do you do about it? Do you delete it? No. That's one of the worst things you can do, because it's never really deleted. No email is ever really deleted. It's never really gone. It's somewhere. The very first time it was sent, it's on the computer that sent it, it's on the server that relayed it from your ISP, the sender's ISP, and yours. It's at least 4 or 5 places just at the time you open it up, and maybe many more. And deleting it doesn't do it from a good forensic examination of your disk anyway. But anyway, that's not the goal. The goal, again, is to turn it into a public record. Your best protection when you get that, when someone sends you this, rant or rave or thoughtful white paper on why you should do something or why something should be approved or denied, send it on to your staff person on the zoning board, send it to Jody, send it to Kate at the planning board, send it to Nancy or the councilman, send it to them, forward it on, and then she'll print it out. Put it in as part of the record. It will be official. It's there. We're not hiding it. And if anybody wants to see it, including people who have the opposite point of view, they'll be able to see what was written and said. It won't be hidden. It'll be out there in the public. And if you really, and Governor, you can say that too, you can say at a meeting, I've gotten several emails, I've given them to the clerk. You can do that. That's the best way to deal with those unsolicited communications that you get. Yes?
For those of us that don't have the staff, would you just bring them to the meeting as a printout and give them to the secretary?
Yep, that would be fine. Or forward the email, you could do both. I'd say forward the email to the secretary or of the commission, yep. Yes?
So you're saying that if you attend a public meeting, a public board meeting,
Right.
and you have input you'd like to give in a written form to
Yep.
them at that meeting,
Yep.
that's an acceptable procedure? Or does it have to go to them prior to the meeting, either by email or by, snail mail? Can someone take a correspondence or an opinion and hand it to the planning board, for example, and say, I would like this communication to become part of the public record of this meeting? Is that, or to each of those members, is that an allowable thing or not?
Yes and no. Because it depends, and that's what I talked about at the beginning, the difference between what's a public hearing and what's just a public meeting. If it's a public hearing, if it's an open public hearing before the planning board, yes, you have the right to submit it. Now, some boards have rules, they like stuff submitted in advance. To the extent you can get it submitted in advance, it often helps the people that have a chance, if it's a lot, people have a chance to read it in advance. So it's good to try to get it to the clerk of the board beforehand, get it to the secretary of the board, so that he or she can get it out with the packet of materials. Get it there, or even tell them. We've gotten several letters from, we've got 500 letters from the neighbors. I'm keeping them in the office if you want to come in and take a look at them. That's the way to do it. Now, not every public meeting is a public hearing, so no, there may be some meetings, particularly if it's not a public hearing, where the chairman will be saying, no, we're not taking public comment, and that includes written comments either. Or either it's just not that kind of action that doesn't call for a public hearing, or perhaps it hasn't happened yet, or it's already closed. So you don't always have the right to submit something like that. The only thing you gotta do is, it's gotta be fair. If the chairman decides to take something from one person, they're gonna take it from everybody. They can't just take it from someone other than staff. Staff comments can be there, but again, have to be available to the public to see, but they don't have to take it from the public just because they're taking staff comments. Okay? Another thing to think about is private field trips. Talked about you going to look at something. Just be careful when you're there about talking to the applicant or his or her representative. If you're just going to look at the property, that's great. You know, if they see you there and they come out and talk to you, oh, aren't you on the zoning board? Here, let me show you, you know, you want to be careful about that. You want to try to avoid that. Say, no, I think I'd just like to see it from here. It's much better if you're going to have it, and it's dealt more with the planning boards and larger properties, it's something you can't see from, even the zoning board, if it's something you can't see from the street, then the best thing to do is to have a site visit. And we actually have done that. I've done that a couple of involved with institutions, private schools and whatnot. You know, they're doing something in the back 40, there's no way you can see it from the street. So let's schedule a Saturday morning site visit for the zoning board. We did this. Of course, it was freezing cold. I don't know why they're always in the worst weather. But have a site visit, go out there, and it's noticed. And in that case, where it's an official site visit, then you can have someone there who says, okay, this is where we're proposing the new building. And by the way, we've got it staked out. See this stake, this stake, this stake, that's where the new one's going. People get a chance to look at it. And it's a public meeting, since it's a public site visit, and I highly recommend that. If there's something, if it's not something you can easily see from the street. The members can talk to each other, yes. Just, you don't go off and whisper to one another, and particularly if there are members of the public around, you want to be speaking up, so again, so that they can hear what you're saying. That's all that, they don't have the right to chime in themselves, but the public has the right to hear and see what you're saying. And then they can do it. I mean, I went on one, I was representing some objectors, and it was a planning board site visit for this big farm, and it was a Saturday morning thing, and I'm out there with my client, and we're listening. It was good, because, you know, we could hear the applicant saying, you know, and over there is fine, there's no wetlands over there. And so that's what we had the right, to be able to hear that, so that we knew at the next meeting when we came into the hearing room, then we could produce and say, you know, they told you on the site visit there were no wetlands there. Here's a copy of the soils map. Look, it's full of wetlands. That's the right that the people have. Not there on Saturday morning to say, whoa, that's wet, but to be able to hear what's being said so we can respond to it at a later time.
Do you need an agenda for a site visit?
Yes, you do. Doesn't have to be much, but you do need a posted agenda for a site visit. And specific enough to the location so that people can find you. If it's a big, huge property, and I think we've done that, you know, such and such a parking lot, or a parking lot, ride lot, or whatever, so that people can find it. Did you have
I have the same question.
Okay. So, I mean, I highly recommend it. We live in a small state. It's not like we're going to drive 2 hours to get to the site. Sometimes there's nothing better than actually walking the land and seeing for yourself. So, now I understand, most of the zoning board ones, you're just going to drive by and look at it on your own time, and that's fine. But just avoid the conversations if you are doing that. So. I'm going to just conclude with coming back to what I said. I'm going to talk about some of the benefits and just kind of what I was saying at the beginning. That's the public, and there's a variety of benefits if you do these things. Aside from avoiding fines and jail time in the worst instances, but you'll establish your credibility and the credibility of your body. And that's important because, as I said, you're the government to these people. And, you know, the people before you as an objector today may well be an applicant tomorrow. There may be the people who are going to decide to become board members in the future. You want people to participate in the town. You want to have credibility. And you don't want to be wasting your time, too. I mean, if you're spending all these nights for nothing as a volunteer, don't you want people to at least, you know, find you credible and respect you? And you want to create an atmosphere in the community as whole that supports the community and the community feelings. And too often we don't. Too often we become all splintered and polarized. And sometimes you just can't do anything about it. People will disagree on, is this in the public good or not? But at least let them disagree on, is this good for the public or not, rather than, how did this get to be such an inside job? Let it be a discussion on the true merits, rather than griping and whining about the procedure and how it wasn't fair. That people will walk away and say, well, I disagree, I think it was the wrong decision, but, at least they made the decision. It was an open decision and a fair decision, even if they were wrong. And then you also avoid the reconsideration. As I indicated, oftentimes mistakes in these things, aside from the personal things, don't help the applicant at all. Many times, anything that's a violation of the Open Meetings Act means you got to go over and do the whole thing over again. And that doesn't help the applicant. That may kill a project right then and there because of the time. You tried to do them a favor and save them a month, and you may lose 6 months or a year in doing it. Likewise with appeals, if there's problems, it allows someone to take an appeal to court and delay or stop it that way. As well as the expense, if you have real violations of due process, you can be costing your community money in lawsuits or even legal fees to defend it and increased insurance costs to defend them. So for all these reasons, I urge you to do it, as well as a good old Facebook. As I said, the Facebook test will be the new one. So those will be the things that I leave you with. Remember, no reply all, and think of what you would think of your action is all over the internet, all over Facebook tomorrow morning. So other questions? So I'll hang around if people want to ask private questions, but with that, I guess, entertain a motion would the chair want to entertain a motion to adjourn? Okay.
I guess I could, but.